We're ready. My name is Shepard. I'm an emerita from Teachers College, and I speak today for the three organizations that sponsors these talks at Morningside Gardens. Emeriti professors in Columbia, the School of Professional Studies at Columbia, and Morningside Health and Retirement Services, MRHS. This afternoon's talk is the 14th in a 3-year series. We sponsor talks on diverse subjects. Today's talk is about the continuing struggle in this country to create a public school system that is universal, open to every child, no exceptions, and equitable, meeting the same standards of quality for every child. Popular news sources tell us that kids attending public schools in the city and public schools in the suburbs in this country are different. Now, those differences don't necessarily mean that the education can't be universal. But the whole question of whether a two-track system of education is equitable is harder to support. Especially when we're hearing public reports from places like Los Angeles and Chicago and Detroit, where the schools are in chaos much of the time. Seeking a clearer picture of the status of public education in our country, we ask a person with considerable experience litigating for educational rights for children, especially children who are likely to have those rights ignored. We wanted this person to talk to us about the status of our cultural goal to achieve universal, equitable public education. Michael REBELL, who's speaking today, grew up in Brooklyn, went to Harvard, considering a career as a China specialist, served 2 years in the Peace Corps in Sierra Leone, earned a law degree from Yale, and then settled into a law practice in New York City, protecting the educational rights of vulnerable children. Around 2005, he joined the faculty at Teachers College at Columbia and also at the Columbia Law School. I'm not going to give a standard review of his credentials. He does everything that a successful professor in a major university does: writing, consulting, lecturing, everything. But I would like to make a couple of comments about him, about his work situation. As I've just said, and as many of you know, he has an appointment in the law school and an appointment at Teachers College. And among the many benefits that can bring, he is able to teach at least one course a year that involves people who are preparing as lawyers and people who are preparing as educators, so that those two groups of people get to study and learn together. The second thing that I would like to mention about his work is that around the same time that he joined the faculty at Teachers College, he created an administrative unit called the Center for Equity in Education, right?
Educational equity.
Educational equity, okay, sorry. And that, now correct me again, Michael, if I need to be corrected. That institution works primarily to serve poor children, right? And so kids in poverty, and it's a research and policy organization that works to explain the educational needs and educational services for poor children. And you also spend time studying and recommending out-of-school sources for those children. So the third and last thing I wanted to say is that Michael, and you, correct me if this is offensive, didn't come to Teachers College to sit in an ivory tower. He came to Teachers College to assume, and Columbia Law School, to assume all the responsibilities of a university professor and to continue to litigate cases. And taking your students with you, I presume, which is an ideal situation for them. So without further comment, I turn this over to you, Mike.
Well, thank you, Joe. I appreciate that introduction, and I'll just mention my first contact with Joe Shepard was, I guess, probably more than 20 years ago when we were beginning to put together the major litigation that was known as CFE versus State of New York, and that was a challenge to the, no, I guess I knew you before that. It was from the Jose P. case.
Yeah, it was
Which
Jose P.
Oh, I'm sorry, I'm getting my cases mixed up. Okay, that was a class action on behalf of disabled students. We have a class of 160,000 students with disabilities in New York City, and Joe was one of our fantastic expert witnesses that helped us win that case and get a lot more benefits for students with disability. They still haven't gotten everything that they need and that the law promises them, but that was a major victory along the way, and that case is still pending. I've gone on to other things, but my former colleagues are still fighting for the rights of kids with disabilities. Okay, I'll mention a couple of the other litigations that we're involved in and have been involved in along the way, but the assignment I got for today's course is really it's not a course, it's a lecture, I guess. It's quite challenging because Joe asked me to summarize 65 years of legal and political and educational history in asking what happened since Brown v. Board of Education in terms of equal educational opportunity. So I'm going to try to do that, and it's actually very appropriate to have this theme this week, because as many of you may know, this Friday will be literally the 65th anniversary of the famous Brown v. Board of Education 1954 decision. So I'm going to try to tell you what's happened since then and what may be possibilities for the future. One of the interesting things about Brown, I'm sure you all know the essential essence of Brown. It was this landmark decision. Many people have called it the most important Supreme Court decision of the 20th century that outlawed racial segregation in the schools, and on the basis of that holding, the Supreme Court went on to outlaw racial segregation in many other areas of life. One of the strong precedents that was established in that case was the concept of equal educational opportunity. The court repeated that phrase no less than 5 times, that every child in the state that promises universal education has a right to an equal educational opportunity. So we're going to kind of track where we are 65 years after the Supreme Court first announced that basic breakthrough legal concept. Now, one interesting little anecdote that I always find quite interesting when you look back on it historically is on that famous day, May 17, 1954, after the Supreme Court announced this breakthrough decision, the press, of course, swamped Thurgood Marshall, who was the main attorney for the plaintiffs, and said to him, well, now that the court has outlawed racial segregation in the schools, how long, Mr. Marshall, do you think it'll be before we actually achieve that goal of fully integrating all of our public schools? And Marshall's answer was, well, it's not going to happen overnight. And I think it'll be at least a good 5 years before we get full integration in the schools. Well, that was 65 years ago, and from the reaction, I know you all know, we are far from having full integration in our public schools. So what happened along the way? Well, To begin the story, after deciding the basic constitutional point that racial segregation in public schools is unconstitutional, the court faced a really big challenge, and that was, well, exactly what is the solution going to be to desegregate the schools? What is our order going to mean? How should we shape it? What should we require school districts throughout the country to do to observe the Constitution as we've now interpreted it? And they took another year to think about that remedy, and they asked the lawyers in the case to submit further briefs on how should we implement this new constitutional requirement. And they invited every attorney general in the country to submit their position on what should the court do. So after taking another year and having more legal arguments, they issued a second decision known as Brown 2. And Brown 2, in many ways, well, I won't say it's more significant than Brown 1. Brown 1 is still a vision. It's still a motivator for all of us who work in this field. But Brown 2 got into the nitty-gritty business of how we actually going to achieve desegregation. And the court did, I would summarize it by saying two things. They first decided that they were not going to issue some blanket order that would immediately tell every school in the country what to do. That was too big a demand. The country is too complicated. So they said, we're going to send this issue back to the federal district courts in each of the states to work it out in terms of what their local needs were, what the local problems were. And at the same time, they did give the lower federal courts enormous power to solve the problem. And they said that the courts should do whatever is necessary to achieve the goal of desegregating the schools. And that may mean not only physically moving children from one school to another, opening up all-white schools that had previously prohibited enrollment of black students, but it said the court had to consider faculty integration, they had to consider building access issues, they had to consider the whole range of curriculum, the whole range of educational issues to get meaningful integration. So the fact that the court took such a thoroughgoing approach to how to solve this problem was significant both for laying out the terrain for how to solve the segregation problem, but it also set a huge precedent on the involvement of courts in policy areas in general. Because since Brown 2, as many of you probably know, we've had judicial involvement in numerous areas: rights of the disabled, gender equity, student rights in schools of all kinds. Outside of schools, we have the concept of court intervention to provide rights for people who are confined to institutions for people with various disabilities. We have the whole range of rights that the federal courts have developed and the state courts have developed since that time really came from the stance that the court took in Brown 2 in saying the courts have to be thoroughgoing and have to get involved in the policy issues in order to solve the problem. At the same time, however, because some of the justices were concerned about resistance, about reactions, and wanted to avoid a huge confrontation, mainly in the southern states, with those who would oppose this edict, said, let's not rush into it. So they used the phrase that the federal courts in each of the states should go ahead and work on this problem of desegregation with all deliberate speed. They didn't put any timetable. They used that phrase, all deliberate speed. What exactly does it mean? I mean, speed, okay, fast, but deliberate seems to indicate slow. So it's ambiguous, and you could take it any way you want. And you know, the Brown decision was unanimous, Brown 1 was unanimous, Brown 2 was unanimous. When we look back to that, to think of the Supreme Court justices, all 9 of them voting together on important, major breakthrough developments like this is incredible, because we don't have that anymore, with very rare exceptions. But of course, the way Chief Justice Warren got a majority to go along, not only with Brown 1, but with Brown 2, sometimes you have to make little compromises. So some of the justices were concerned about moving too quickly, and therefore part of the compromise they worked out to get unanimity was this phrase, all deliberate speed. Okay, so what did all deliberate speed mean? It meant basically that for the first 10 years after the Brown decision, the Supreme Court virtually stayed out of the fray. And they didn't press the lower courts to move quickly. As you know, a lot of political resistance did build up in the South, violence in many areas, and they just left it to the lower courts to deal with this as best they can without any further guidance from the Supreme Court. But by the mid-1960s, I guess the court had decided that we've been deliberating long enough, it's time to speed things up. So the first major ruling they issued in the mid-60s had to do with a Virginia school board that had been resisting court orders for the 10 years or so since Brown. And it was a small district that logically could have been integrated very easily. It was a small rural district that had two schools, a black school and a white school. And it was a small area. So people could easily walk or move to whichever school is closest to their houses without busing, without all the complications of that. If you wanted to integrate those schools, you could have done it virtually overnight. And here it was 10 years later, and they were not at all integrated. So the court issued a very clear order. Again, it was unanimous. The time had come. And they said to the district court, you tell the state authorities in Virginia, no more stalling around. They have to come up with a plan that works and that works immediately. So that was a pretty clear message that the time has come, we need business. A few years later, there was a major desegregation case in North Carolina, the Swan case, and that one did concern a large district which had complicated issues as far as achieving desegregation. Busing was the major one because this was in Charlotte, Mecklenburg, and that district included both the urban area of Charlotte, but the rural areas outside of it. They had been combined into one school district. The suburban area was mainly white, the urban area was mainly black, and the court in that situation did put into effect a very strongly worded order that required all of the things that the opponents of desegregation were worked up about, and quite frankly, the Nixon administration at the time was working against politically. The judge's order required extensive busing to move the kids around to make sure that you could get a racial balance. It involved numerical guidelines. They weren't exactly quotas, but it was saying to make sure that we can track progress toward integration. We're going to look to what the ratio of black and white students is in every school, and if it's way out of kilter, then it's got to be corrected. So that some people would interpret as quotas, some call it numerical guidelines, but that was in the judge's order. And there were a number of other specifics, details that were going to make this plan work. Of course, the defendants appealed it, and it went up to the U.S. Supreme Court, and is this going to be what's required? Well, to the surprise of many people at the time, again, the Supreme Court came up with a really strong order that was unanimous, and that included the votes of Chief Justice Burger and other judges that had been appointed by Richard Nixon, who was not known for being a great adherent of rapid integration. But nevertheless, the court as a whole upheld that plan. And they said, yes, if it's necessary to achieve racial integration, busing is constitutional, busing can be required, numerical guidelines can be required. So again, this was a very strong message that the Supreme Court meant business. And at the time, you had also Congress laying out the groundwork that helped all these court orders really become practical, because Congress in the mid-60s, especially with the 1964 Civil Rights Act, had done two things. They first of all, well, I should say, in addition to the 1964 Civil Rights Act, there was the 1965 Elementary and Secondary Education Act that Lyndon Johnson pushed through. And the Elementary and Secondary Education Act provided large-scale federal funding to the states for education for the first time in history. There have been small education funding appropriations, but over the years, federal funding for education had been a big issue. It got tied in with aid to religious schools, all kinds of political issues. Johnson pushed it through. So starting in the mid-60s, public schools throughout the country were slated to get large amounts of money. And we still get large amounts of money under the Elementary and Secondary Education Act, which is now called ESSA. It was called No Child Left Behind a few years ago, but that's this basic federal funding for so-called disadvantaged kids. But it started then in '65. About the same time, a year earlier precisely, Congress passed the 1964 Civil Rights Act. And the reason that was important is that one part of that act said that any public agencies that were not complying with constitutional requirements, with legal requirements, could face as a sanction cutting off of all federal funds. So what you finally had in the 60s, what you might say is a carrot and a stick. The carrot was you're slated to get all kinds of new federal money. But the stick was you don't get the money unless you follow the court orders and you do what's necessary. So you had Congress really working together with the courts at the time. And under the Johnson administration, you also had the Office for Civil Rights and the old Department of Health, Education, and Welfare that was following up and tracking what school districts were doing in different parts of the country, not only in the South, but also in the North. So it was kind of a coming together of the three branches of government working harmoniously to achieve this result of racial integration. And they did have fantastic success. In 1964, when all of this was first coming together, something like 98% of the African American students in the South were attending schools that were more than 90% African American, totally segregated schools. And the inverse, of course, was almost the same percentage of white students were attending virtually all white schools. By 1972, a mere 8 years later, the number of, the proportion of African American students in those totally African American schools was down to less than 9%. So you went from 98% to 9% in 8 years. And that was under the Nixon administration during the last 4 years. That's how powerful the movement was at that time. So you might say, all right, it wasn't 5 years after Brown. We're talking about 1972, 73. So maybe it was going to take them 20 years, 25 years. But if we're going in this direction, maybe we would have achieved full desegregation and be on our way to equal educational opportunity maybe within 25 years. But something happened along the way that was a stumbling block to that kind of progress. And that something was a dramatic shift in the position of the U.S. Supreme Court starting around 1973. And we could spend the rest of the afternoon talking about why that shift occurred, whether it was new appointees on the court, whether it was a feeling that they had taken on too much and they have to cut back because not only Brown, but everything that followed from Brown was getting the courts involved in a huge amount of involvement in policies and education and other areas. Anyway, I'll leave that conversation for another day. The bottom line, though, is starting in 1974, the Supreme Court no longer was issuing decisions that were promoting and seriously aiding the process of school desegregation. And the first major decision that announced that this was happening was known as Milliken, and it had to do with desegregation of the schools in the Detroit, Michigan area. The judge there had found that there had been intentional racial discrimination in Detroit, and for a remedy to make sure that we had a plan that works and works now, which is what the Supreme Court had said in that Virginia case, and that applied to every part of the country. So that judge took it seriously, said if we want a plan that's going to work and it's going to work right away, what we've got to do is bring in 54 suburban districts, and we've got to set up a plan for busing, which the court had said was constitutional under that Swan case. And we've got to have numerical guidelines, and we've got to have an effective plan, just like in Charlotte, Mecklenburg. But this time, the Supreme Court overturned that judge's decision. And their reasoning was that, yes, there had been intentional discrimination within the city of Detroit, and that led to segregated schools, but there had been no proof that any of these suburban districts had a role in that. So since they were, quote, innocent, you can't impose this remedy on them. So the Supreme Court said to the judge in Detroit, you have to come up with a new remedy that's only within the physical boundaries of the city of Detroit. Now, since the city of Detroit was overwhelmingly African American at the time, there was no way you're going to have effective desegregation in a overwhelmingly black district. So the Supreme Court was saying for major metropolitan areas, especially in the north and the west, we're not going to be promoting effective school desegregation. And that was the message, and that has largely been the result. Now, there was one other decision I'm going to mention quickly. We could go through a lot of them, but the other one that was really important was the Keyes decision in Denver, Colorado. And that's where, among other things, the Supreme Court clarified an issue that had been ambiguous in Brown. And Brown talked about equal educational opportunity. It talked about the stigma that's imposed on minority children when the state imposes a discriminatory segregation system on them. But it didn't make clear whether the Constitution was outlawing only segregation that's required by law or by intentional acts of public officials. That's what we call de jure segregation by law, or any kind of situation that results in segregation, whether you can trace it to a law or just social patterns, or mainly housing patterns, which is what causes segregation in many areas. And that's known as de facto. It's segregated as a matter of fact, even if no law actually required it. So in places like Detroit, places like New York, there was a lot of segregation. In fact, even though, unlike the southern states, no law in New York or Michigan said schools have to be segregated, but the housing patterns were what they were for all kinds of reasons we could go into, but it didn't result from a law that specifically said blacks have to live here or whites have to live there, or blacks have to go to a certain school and whites have to go to another school. So in this Denver case, the lower courts were split on this. Did Brown mean that only intentional segregation that's required by law or by official actions of public officials is what Brown covers, or does it also cover any segregation? Because any segregation has harmful stigmatic effects, arguably, certainly on black children, maybe on all children. Anyway, in this Denver case, the court said the Constitution outlaws only de jure. So there again, they're sending a message that for the North and the West, unless a plaintiff can prove intention that there was clear discriminatory intent, even if there's a segregated pattern, the courts are not going to do anything about it. And that's pretty much the state of the law where we are now. Interesting little aside, there was a separate decision by Justice Powell, Lewis Powell, who was from Virginia. And he opposed that part of the decision in this Denver case because he said, isn't it interesting? This is the first major case that has to do with the North and the West. And when the issue is desegregating their schools, all of a sudden we find some way of making a legal distinction and they're off the hook. But when it came to Virginia and the Deep South, the court didn't hold back. They're ordering us to do everything. So we had a little bit of a regional rivalry there. Okay, there have been further court decisions. The most recent one was the parents involved decision in 2007 that many of the current members of the Supreme Court had a role in, or several of them. And that makes it difficult to even have voluntary desegregation plans. So it's pretty clear the message coming from the federal courts these days is not promoting desegregation in the schools. All right, where does that leave us with our concept of equal educational opportunity? As you know, the federal courts certainly are turning in a more conservative direction these days. So is there anything else to talk about when it comes to equal educational opportunity? Well, there is. So I want to tell you where the reform movement, as far as legal advocacy, turned after Milliken, after it became clear that the federal courts were putting a lot of roadblocks into effective racial integration, certainly in the North and the West. And what happened is a lot of the advocates turned to the question of funding. And basically they took the position, well, if we're not going to have real racial integration, let's at least make sure we have sufficient resources so poor kids who are going to be in segregated schools can have a shot at equal educational opportunity by having well-trained, well-equipped teachers, reasonable class sizes, up-to-date books, modern facilities, all the things you need for a good education. So that issue came to the Supreme Court actually around the same time as that Milliken case I mentioned, where they slammed the door on further racial desegregation. They also slammed the door on this idea of fairness in funding. The famous case in that area that went to the Supreme Court was the Rodriguez case in 1973. And the issue there had to do with the funding in the state of Texas. And the plaintiffs came from a very poor school district named Edgewood near San Antonio, Texas. And the San Antonio metropolitan area had 7 school districts closely in that metro area. So Edgewood was this poor 95% Latino district, and it was geographically right next to Alamo Heights, which was a virtually all-white, much more affluent district. And literally, depending on which side of a major avenue you lived on, you were either in this poor district or you were in this wealthy district. Now, although the needs of these kids, many of them didn't speak English, immigrant backgrounds, etc., because of the way the funding for education worked in Texas at the time and still works in many places, including New York, and if I have time, I'll get to that before we finish. A lot of education funding comes from local property taxes. And that means if you live in a district where housing prices are very low, even if the people vote to tax themselves at a high rate because they value education, you can't raise very much money. Whereas if you've got a very wealthy district where housing prices are much higher, with the same tax rate or even a lower rate, you can probably raise a lot more money for your schools. So that was exactly the situation in this San Antonio area. And these plaintiffs presented what we in the legal trade would call an ideal case, because the facts were perfect. Basically, what happened is, in Edgewood, the poor district, the people taxed themselves at a relatively high rate, 25% more than the tax rate in the neighboring rich district. But because the value of their property was so low, they could only raise half as much money per capita as the people in the rich district, even when you counted the federal aid for the disadvantaged. So these kids with greater needs, taxing themselves at a higher rate, had about 50% of the money spent on each of them as the kids in the rich district. This is the case that went to the Supreme Court, and it was a crying inequity. At the time, most of the civil rights advocates said, there's no way this case can lose. This is so overwhelming. It's so unfair. And, you know, this was at the heyday of Brown. This was before Milliken. So desegregation is moving ahead. And the argument was, well, you know, we've achieved a lot of desegregation, especially in the South. But what we found is, what's happening, we have a lot of poor white kids attending school with poor black kids, and none of them have enough resources to have a real educational opportunity. So the court's got to correct this. Well, what happened in Rodriguez? Rodriguez was the year before Milliken, and it was really the first indication that the court was going in a more conservative direction. Because what they said there is, yes, this is a terrible inequity. Somebody should do something about it, but it's not going to be the federal courts, because there's not a word about education in the federal Constitution. It's not our jurisdiction, so we leave it to the states. This is an unfair system. They ought to do something about it, but the federal courts are not going to be the place that you're going to get any relief for this. So, that having happened, people at the time on the advocacy side were really despondent, because historically the state courts had been much more conservative than the federal courts. And for the federal courts to say, go to the state courts and maybe they'll do something, was like saying get lost, because there was no expectation the state courts were going to do anything. But lo and behold, we did get a surprising development. So there is a little light, if not at the end of the tunnel, at least at the beginning of the tunnel, because plaintiffs did go to the state courts, and in the late 1970s, all of a sudden there were a series of decisions that were finding in favor of plaintiffs on this fiscal equity point. There was a major decision from the California Supreme Court, the New Jersey Supreme Court, the Connecticut Supreme Court, the West Virginia Supreme Court, and California was most blunt about it. They said the federal court said there's no right to education under the federal Constitution. Well, we're going to hold there is a right to education under the California state Constitution, and we don't care what the federal court says. We're going to say that this kind of pattern of unfair funding is unconstitutional in the state of California, and the state has to do something about it. So, first cases out of the block, plaintiffs are winning big time. Well, once attorneys in other states saw that happening, they rushed to get on the bandwagon. So in the next decade, in the 80s, we had about 22 cases decided in all parts of the country. But suddenly the outcome kind of shifted. During the decade of the 80s, the plaintiffs only won about a third of the cases. They lost 2/3 of the cases. But then the interesting thing happened. Starting in 1989 into the 90s and the 2000s, the pendulum shifted again, and all of a sudden plaintiffs were winning 2/3 of the cases. I don't have time to get into all the details, but the bottom line is, over the last 45 years since this Rodriguez case, we've had state court litigations on education funding in 47 out of the 50 states, and overall, the plaintiffs have won 60% of them. And there are a lot of interesting doctrinal reasons why we had these shifts back and forth. I'll just tell you from my own personal experience, I brought the main fiscal equity case here in the state of New York, and we filed our case in the mid-1990s. There had been a case in New York in the 1980s where the plaintiffs lost. And what we did is look at a different part of the Constitution, the state Constitution. Instead of looking at the Equal Protection Clause, we looked at an education clause that had been written in the 19th century. Some of you, I'm sure, are familiar with Horace Mann and the Common School movement, which was this major breakthrough in the middle of the 19th century that established our public school system. It said we're going to have a system of free public schools. And that was a big battle in the 19th century. There was a lot of opposition to it. but the reformers won. And after they won, they wanted to put it into the Constitution to make sure that if the other side got control of the state government, they couldn't easily undo it. So they put some language in the Constitution in the 19th century that said, the legislature shall establish and maintain a system of common schools in which all the children shall be educated. Well, that's very nice. It says we should have a system of common schools. Does it specifically say they all have to be fairly funded? Does it specifically say they have to be funded at an adequate level? Well, it really doesn't. But because we had lost, or my predecessors had lost using other legal theories, we said, we're going to tell the court they've got to give some meaning to this kind of vague language from the 19th century. And nobody had ever brought a case based on that language because they all thought it was kind of aspirational. They just put it in the Constitution. We have had a common school system. We now call it public schools. But whether that really requires any qualitative level of effort seemed to be a long shot. And I will tell you that when we first started considering this case, I told the group we had, gosh, we're running out of time, but I'd love to share with you some of the stories about how this case got started. It got started basically because of a community school board president from a little north of here in Manhattan, a guy named Bob Jackson, who's now a state senator. Maybe he represents this district.
Yes, he does. Yes.
Okay, so Bob Jackson was then the chairman of Community School Board 6 in Washington Heights. And one of the things I was doing, I was a lawyer for a number of the community school districts at the time. Bob comes into my office and says, Michael, they're cutting education funding, we're getting killed, huge class sizes, we're laying off teachers. The state funding formula is unfair. It's based on all this property tax stuff, just like that Texas thing. You got to bring a case. And I said to him, Bob, you're absolutely right. The funding formula is unfair in New York City and a lot of other poor districts in the state, but somebody beat you to it. There was a litigation 10 years ago in New York, and the plaintiffs lost. And 10 years may sound like a long time, but I'll tell you, I can't go in there and tell the judges, you know, you guys were wrong, reconsider what you did 10 years ago. And Bob Jackson wouldn't take no for an answer. And he said, politically, we're not going to get anywhere. The only hope is the court. You're a smart guy. Come up with some new legal theory. So he forced me to go to the law library, and we came up with a new legal theory. And I said to him at the time, Bob, if you think you can't get anywhere politically, this is the only hope. All right, we're going to rely on this language from this 19th century thing. It's not equal protection, so it's a different argument, which means the court can't sanction me for bringing a frivolous case, but I'll tell you, the odds are probably less than 10% that we'll ever win. All right, so we went ahead. We had many of the community school boards. We had most of the parent groups in New York City supporting us. We formed this group called Campaign for Fiscal Equity, and we brought this litigation. Again, I want to leave some time for questions and all, so I'll skip over the next 14 years. But the long and the short of it is, with all the appeals and all the discovery and a 7-month trial, we won. And in 2003, we got a wonderful decision from the highest court in New York State, the Court of Appeals, that interpreted that ambiguous language from the 19th century in a very strong way. They said, well, that language that all the kids must be educated has to mean some kind of education, so it has to be a sound basic education. So that was what they gave us as marching orders the first time we went to the court. So then they said, all right, go back to the trial court, bring in all the experts, and tell us what sound basic education should mean. So after we went through all this, we went back to the highest court. We came up with a definition, and it's a really solid definition. It is now the law of the state of New York what a sound basic education means. And it means that every child in this city and this state has a constitutional right to an opportunity to develop the skills they need to function productively as civic participants capable of voting and serving on a jury. And the productive part means also being prepared for a decent job. So kids have a right to an education that prepares them for competitive employment and prepares them to be active, knowledgeable citizens in a democratic society. And I think that's a wonderful definition for the 21st century, the legacy that our pioneers in the 19th century who wrote that language, I hope they're pleased with it, because Judge Kay, who wrote this fabulous decision, Judith Kay, reached back and she looked to a report of the Constitutional Convention from 1893 where they wrote that language. And in the report, the drafters of that language had said, it is important that we have adequate education, not only for kids in our time, but for the generations to come. And Judith Kay was kind of speaking in a time machine, and she said, and they were telling us that we have to keep current with what the needs are in our time, and that means we've got to have schools that are adequate for the 21st century. So that's the law in the state of New York. Not enough people know about it. Not enough has followed through on it. Part of it is that what Bob Jackson and most of my clients at the time were interested in is how much additional funding are we getting? That all legal language sounds great, but what does it mean in practical terms? Well, what it meant is when the dust settled after CFE, the legislature adopted a foundation aid formula and committed themselves to increasing funding over a 4-year implementation period, phase-in period, by $9 billion for the state as a whole, $5 billion for New York City, $4 billion mostly for other high-need districts throughout the state. Well, that all was 2007, it was 12 years ago. And things went well the first 2 years after that commitment was made by the state. We got substantial increases in funding for those first 2 years. Then the recession hit. And once the recession hit, first they froze any further increases, and then when the recession got worse, they started cutting dramatically. And ever since 2011, we've been playing catch up. And with inflation and everything else, I'll tell you right now, statewide, we've gotten about $5 billion out of that $9 billion. The state still owes $3.5 billion. We've had to bring another lawsuit, so we're still pushing on it. In a nutshell, that's where we are with CFE, and the follow-up, the new case we have is called NYSER, New Yorkers for Students' Education Rights, and that case is pending. So maybe if I come back in another 5 years, we'll have a result for that one. Okay, I've tried to cover a lot of ground. I'm going to mention one other thing and then open it up for questions. We've made a lot of progress in New York, but I mentioned to you that although we've had these litigations in just about every state, plaintiffs have won 60%, but our side, and I'm very much involved in these cases nationally, we've lost 40%. And I'll tell you, in those states where we've lost, you really have a disaster. Joe mentioned Detroit, which people talk about it's a non-system, it's a disgrace what's going on there. Chicago, those are all states where the litigation's lost. And even though we're still saying we're entitled to more funding in New York and we're looking for high quality, kids in Chicago get about 60% per capita of what kids get in New York. So as bad as things are in some of our public schools, they're much worse there. And I think it's time for a national solution for all of this. And if we need to revive the vision of equal educational opportunity from Brown, I think we need a coordinated, cohesive national strategy. We can't have a situation where breakthroughs occur in a few states here and there. There's backsliding in some states. There's no consistent understanding of what equal educational opportunity is. I don't think with this court we're going to get a reconsideration of a lot of the negative decisions that have directly dealt with the Brown issue with racial segregation. But I do think that there's a way of taking an indirect route, both to get more funding, to get it consistently on a national level, and to start a new way of looking at how to deal with diversity and racial integration in our schools. And that is looking at that language from CFE. If you remember, the emphasis the court came up with was that there's a right to develop the skills you need really to be a capable citizen, to exercise your First Amendment rights, to exercise the right to vote. Those rights are more important now, I think, than any time in our lifetimes. We all know that our democratic institutions are under assault, and we're taking the position that even a conservatively oriented Supreme Court may be open to arguments that there should be a federal right to an education to prepare kids to be capable citizens. And that would mean all kids throughout the country. Essentially, we're asking them to reopen the Rodriguez case. I can't go into the details on it, but Thurgood Marshall had pointed out when he dissented from that decision that although, yes, there's no language in the federal Constitution that talks about education, so that right was left to the states. But he said there is a 15th Amendment that says all citizens have a right to vote. There is a First Amendment that says all citizens have a right, not only all citizens, all persons, even non-citizens, have a right to free speech, to participate in political issues, to speak their minds. And you cannot exercise any of those rights if you don't have a basic education. And Justice Powell, who wrote the majority decision in that case, was bothered by that. And he said at the time, well, there may be a need for such a right, but the plaintiffs in this case were just asking for more money. They didn't say their school's not preparing them to be citizens. We'll leave that for another day. So myself and my colleagues are taking the position that the day has come 46 years later. And last November, we filed a new major federal class action in Rhode Island, not in New York, because we already have the right in New York, but we had to pick a state where the plaintiffs lost. There are other reasons we picked Rhode Island. But that case is known as Cook v. Raimondo, and we're pushing ahead there to try to get the court to reconsider what they did in Rodriguez and to establish a national right that, given the climate we're living in, we're hoping it will resonate on a bipartisan basis with conservatives, with liberals. We all should be pulling together for a coherent concept of citizenship. And you know, it's a long haul. The Supreme Court takes what cases they want. You don't have a right to go there. But if we, by any chance, do get up to the Supreme Court, it hopefully will be in the post-Trump era, 2 or 3 years from now. And maybe Chief Justice Roberts and some of the other members of the court would be looking for a concept that might help draw the country together and start talking about our common bonds of citizenship. Some of what's implied in that is taking diversity in the schools seriously. It may be a way of getting back to some of the integration ideas without the confrontation and the history of what happened in all those school desegregation cases. So that's the vision of hope and possibility that I leave with you. It is a long shot, but all I can say is I told Bob Jackson it's less than 10% chance of winning CFE. I'll tell you right now, it's less than a 10% chance that we're going to win this case, but wait and see. Look for it, Cook v. Raimondo. Okay, I didn't leave as much time for questions as I would have liked, but I think we have time for a few questions or comments.
I had read someplace, and I'm not sure of this, that New York schools are now more segregated than they used to be.
That's true.
Why would that be if we have this legislation?
Well, if you mean the court order, that court order didn't speak. Oh, the question was, this woman heard that New York is more segregated than it's ever been. As a matter of fact, when it comes to African American students, New York is the most segregated state in the country now. Part of it, a lot of it has to do with that Milliken thing, that you can't force solutions from the city to the suburbs. And we've had a lot of diversity in the suburbs, although the suburbs now are becoming a lot more integrated, and there are more possibilities because of that. But in any event, New York is very segregated. Our CFE case had to do with funding. So we have an order that says you have to give more funding based on need to kids in low-income areas, low-income districts. but it doesn't say anything about racial integration. The way the housing patterns worked out with the de facto standard applicable, New York is the most segregated for African American kids. If you look at Latino kids, California is the most segregated. So there are interesting changes in the patterns, and segregation is becoming a bigger issue for Latino kids nationwide than it is for African Americans, quite frankly, because they are growing so quickly. In 1970, 5% of our school population was Latino. Now it's 25 or 26. So that's where the stresses are coming in places like California, but there's a lot of stress here in New York for African American and Latino kids.
That was in the article, an article in the New York Times within the last week. There was an extensive article, and that's where that thought came from.
Yes, they had a lot of those statistics about it. Okay, yes, back there.
Question. Like you talk about all the funding, but then you have Obama's head of education, Arnie Duncan, who said New York State had to have 100 charter schools or they wouldn't get state funding. And then we have Betsy DeVos, who has a whole other agenda. So with all these laws, how come, or why can, or however, do these secretaries of education, who in this case has no education, doesn't believe in public schools, how do they become in charge and how do they get so much money to really rob the public schools?
Wow. Well, when you mention Betsy DeVos, I'm not going to get into how she got that position. We all know how she got that position. Okay. She has not been at all effective because Congress ignores her, and they haven't been able to get any more vouchers or charter schools or anything from the federal level. Arnie Duncan was a different thing for two reasons. One, he served under a somewhat liberal Democratic president, and that gave him much more entree from a policy point of view. And second, he had that rare moment. If you remember, right after the height of the recession, we had that Stimulus Act. And the Stimulus Act, to spread money, gave $100 million essentially to Arnie Duncan to spend. And you're quite right. He put a lot of strings on what the states had to do to get the money. So that's how the federal government really had leverage to push for more charter schools, to push for the No Child Left Behind Act being fully implemented. And I don't want to get into the whole charter thing now because, again, we'll be here all day. But if you think that that's a negative development, and it certainly is from the racial integration point of view, that was something that happened under the Obama administration. Yes?
Throwing money at something doesn't always solve the problem.
Right.
The problem that I know about in New York is the fact that they send the youngest, least experienced teachers into the places that that need more teachers and more help. Isn't there any way to solve that problem? The teacher is the basic person that educates the child.
Yeah, I think there's been some progress in that area, by the way. You know, historically in New York City, one of the reasons why the younger, inexperienced teachers tended to go to the schools in the low-income neighborhoods was that seniority rules allowed them to, and the way the funding formulas worked, it didn't cost the schools anything more to have a highly experienced, well-paid teacher than to have a new teacher who was paid a lot less. That's been changed, and schools get budgets now. So if they have highly experienced teachers who are getting a lot of money, they're probably going to have fewer of them because they've got to balance a budget, which they didn't have to in the past. So I'm not saying the problem's been solved. Seniority still holds to some extent, and you know, the union's argument is if you force teachers to go where they don't want to go, the best ones are going to quit, they're going to go to the suburbs, so there's a limit to how much you can do. The real solution, obviously, is to get highly qualified teachers for everyone. And again, we've made some progress on that. People ask me what difference does the CFE case make. I'll tell you this, on teacher quality, which the court really focused on, and it does say in that law that every child's entitled to a qualified teacher. Of course, or defining what qualified means is something else. But when we brought the case, 17% of the teachers in New York City were uncertified. Now it's less than 1%. So on that definition of qualified, which is not, I know, exactly what you were talking about, but at least we're not scraping the bottom of the barrel the way we used to. Progress moves incrementally. What can I tell you? We haven't fully solved the problem. Yes?
I heard that Kamala Harris has an education plan to increase the salaries of teachers across the board nationwide. And I think that might lead to some of what you're talking about, increasing the quality of teachers across the board. And from what I heard, she said that she wants to bring the salaries up to equivalent to other professionals, like lawyers, for example. Even nurses, Right now, I know my daughter taught in Buffalo, and the teachers had to work 2 or 3 jobs.
Yeah, you're absolutely right. And I think the heart of the problem is that certainly in a place like New York, where a talented college graduate can go to Wall Street and make the sky's the limit, or go and teach in a school where they might find more fulfilling, but they have to worry about rent and New York prices and all the rest. So it's a very, very real problem. Everybody was kind of laughing when you said that teachers could get paid what lawyers are. Well, Finland over the last few years has been ranked #1 in the world as far as their performance, their students' performance on all these standardized tests. I don't know that standardized tests are the be-all and end-all, but it does say something. And in Finland, teachers are really highly prized, and it's difficult to get into a teacher school, and they are paid something comparable to what lawyers and other professionals get. So Kamala Harris may be inspired by that. Between it happening in Finland and it happening in the US, we've got a ways to go, but the concept probably is right on. Yeah.
I just want to put a plug in for my book, Desegregation of New York City Schools, with Stories of Silk Stocking Sisters. And I'm very familiar with your work because I've been following you on the Fiscal. I know Bob Jackson, I know back from District 6 and all that, so forth and so on. But I wanted to say and ask you a question, because what I did in terms of my research is look at the stories of women who actually experienced the desegregation experience in New York City schools in the early 1960s, prior to 1965, and the experience of what took place and how they tried to make sure that there were more diverse classrooms. And my talk that I talked about in terms of what's happening next, in terms of looking at the fact that you can desegregate schools, but does desegregation equal economic equality? What you're thinking about that time?
Well, it doesn't equal economic equality, but it certainly moves you in that direction. And some of what we've learned in a lot of the studies that have been done on the outcomes for students who attend desegregated schools is that they tend to do better in life, both in terms of what they earn financially, but also in terms of what kind of relationships they have with other people in our increasingly diverse societies. I think the social science literature is very strong on the benefits of desegregation. And we do have an opportunity now. The city is getting more of an influx of middle-class white people. The suburbs are getting more of an influx of African-American and Latino people. And with all this movement going on, if there were good policies in place, a lot more could be done. But nobody wants to deal with these issues. Certainly the politicians don't. And that's one of the real problems here. And that's why I'm hoping if we can get somewhere with this federal right, it might shake up things and force people to start thinking differently about a lot of issues, including the diversity in the schools. Okay, I think, do we have time for a couple more?
I just wanted to find out what CFE stands for.
Campaign for Fiscal Equity. Okay, this gentleman and that lady back there.
Maybe you just answered my question, I'm not sure, but when you talked about trying to create a right to be a productive, member of society,
Right.
in essence, I was thinking of the segregation issue and how in today's world, the ability to deal with diverse populations really is part of the ability
Yes.
to be a productive, meaningful citizen. It may not have been in days gone by, but is that part
Did
of
you
your
read our
thinking?
complaint in the new case? Yes.
No.
Well,
But I'd like it. No, but it's a serious question.
yeah, if you'd like to see it, we have a website. It's www.cookvraimondo, one word, .info. cookvraimondo.info. Okay, this woman in the back.
Well, in District 3, which I think this is a different district, it's on the Upper West Side, in the bottom of Harlem. There's one school that raises $2 million a year.
Mhm.
You know, they buy the music teacher, they buy the this, they buy the that. So even if the school in, in a poor neighborhood gets more money, like a Title I school, it doesn't compete with the PS 87, who gets $2 million by having a raffle, where you raffle off your house in Provence for a week.
Right.
It's a very different system, and there's no feeling in this district, at least, where the one that has so much should share with the one who has so little. And there was a whole article in the Times a long time ago back in California, some places that give money to another school. That doesn't happen here.
Okay, so you read the complaint in our current school funding case, because we said that's unconstitutional. And,
What, that they raise the money, or that they don't share?
well,
or they
quite
shouldn't be allowed to
frankly,
raise the money?
quite frankly, that the public school system, the state especially, is not providing enough funds so that every school has a music teacher and has a, we're pushing even more for library media specialists. As you talk about what kids need to be dealing with 21st century realities. So no school should be looking for private funding if it's a public school. But you're right, it's an inequity. If resources are short and some schools that have access to parental money are able to raise money, that's not a common school system. You know, Horace Mann said we're creating schools where the rich and the poor can be educated together. And that's not what we have today. You're absolutely right. And we have taken a position that's unconstitutional. So you'll have to stay tuned for the decision in your
The
case.
kids in the poor neighborhoods don't get as much money, or that PS 87 doesn't share, or PS 87 shouldn't, maybe if they were not allowed to raise money, then there'd be a lot more pressure.
Well, my solution to it is that the state should give all the schools enough money so that if PTAs want to raise money to have nicer cakes at the graduation, that's fine. But they shouldn't be paying for music teachers and library media people.
Michael, we have a question from a public school teacher who's come all the way from Bayside, Queens.
Okay, and then maybe, I don't know how long we want to go on.
Part of
but
this
we're fine.
argument lays down the fact, so you want to make it a rule that parents can't contribute to schools,
Do
to
I
their
want to make a
child's
rule?
school. That's what you're pushing for them, that parents can't contribute to their child's school.
I'm saying there shouldn't be a need for it. There shouldn't be a need for it. All these things that have been mentioned so far, I don't know, if you're in a school where the parents are able to raise money, what are they spending it on?
Well, my school actually happens to have, in the high school, happens to have a strong PTA.
Yeah.
They raise some money, but it's not to the level of that particular school. But when you look at what schools in Long Island have done and Westchester have done, they have then, instead of having 3 local elementary schools in the 3 different areas, where you might have a higher income, a middle class, and a lower income in their entire district. So then, you want your child to go to a local elementary school. I don't know how many parents are going to be willing to have their child bus 2 hours when they're 5 to an elementary school, right? So that's where the elementary schools come in. So what they did is, instead of then having it K through 5 or K through 6, if you have 3 schools, they made one school K through 2 and one school 3 through 4 and another school 5 through 6. That way, if parents want to contribute to those schools, right, then they're contributing to their child's schools as it goes along, and it actually has raised the level and equaled it out. But I don't know how parents would support this concept of that they can't provide to their child's school.
Well, we haven't gotten that court order yet, but we haven't termed it in terms of parents can't contribute. We've termed it in terms of the state should be paying for these basic educational resources. And, when I was a kid and we were in public school, the PTA would raise money for an extra projector or some little thing. That's fine, but it's very different when you're paying teacher salaries out of parent-organized money. But, okay, anyway, we had a question over here.
A little bit about all the lawsuits that the Department of Education has and how they have to pay for private schooling for some students because they can't find an appropriate program.
That's for kids with disabilities? Right. Yeah. Well, that's because the federal law and the state law. Oh, I'm sorry. The question was, how does it come about that the New York City public school system and public schools in other parts of the state and other parts of the country sometimes have to pay private school tuition for certain kids who are not going to public school? And there is a right for kids with disabilities under the Individuals with Disabilities Education Act that if the school system cannot provide them a free appropriate public education in a public school, they have a right to go to a private school and get the Board of Education to pay for it. And a lot of parents have taken advantage of that. They have a right to a due process hearing if the school system disagrees with this. And there are a lot of these hearings, and a lot of these parents prevail. I will say that there are probably more kids being educated, kids with disabilities again. This is not all kids. You have to fit under the definition of a student with a disability under the law. A lot more are getting private school tuition paid, and a lot of those private schools are very expensive. And partly because the city is not fighting these cases the way they did years ago. Mayor de Blasio, from what I understand, has adopted a policy that unless it's an outrageous request or something, they tend to give in and settle with parents who want to send their kids to one of the private schools. So there is a legal right, whether it's being abused or not, you may have your own opinion about, but that's how many of these kids get their tuitions paid.
Michael, it seems so unfair because, as we know, it's parents who have money who can afford to hire the lawyers and who know about money. It just seems so unfair. That is stricken me totally free.
Yeah. That's true generally, although there are outfits, like many of you may be aware of Advocates for Children, which is one of the advocacy agencies in the system, that does go to bat for kids of modest income or very low income who need to get this opportunity to go to a private school. Look, the law had a good motivation, especially when it was first passed years ago, and public school systems were not geared up to provide the range of opportunities that you need for kids with all kinds of disabilities. Many of those kids could be well served in a private school. It's become, over the years, a very different circumstance. You have a lot more sophistication, a lot more opportunities within the public school system, but you also have a lot more private schools and people who know how to work the system. But as I say, Advocates for Children, and it's not totally that kids from low-income backgrounds who can't afford lawyers don't have any possibilities. So if you know anybody like that, tell them to go to Advocates for Children and see if they can get help. Okay, should we take a couple more questions? And yeah.
Are there equity issues around chronic absenteeism and responsibilities of schools? Kids who are maybe sickly or maybe in dangerous neighborhoods, do schools have responsibilities to do more to ensure school attendance?
Well, there are programs that I know give school districts incentives, give them extra funding. There's a state program about dealing with kids with those kinds of problems. Whether there's a specific right, You could read it into CFE. I can't tell you that the court has ever identified that. I mean, kids have a right to the opportunity for sound basic education. If they have, for instance, mental health needs that are the reason that they're not attending school, I think there's a pretty good argument that the school has an obligation to try to deal with that to at least some extent. And in our new nicer case, we are pushing for an expansion of community schools, both in numbers and in quality. Because we now have about 200 community schools in New York City, which is a substantial achievement. But again, the funding for them and the quality levels are not what they should be. And by definition, every community school should have facilities for mental health services. And some of them do, and some of them have a lot less service.
It is a factor in low achievement, and I wonder
Yes.
if this has been studied as a...
Well, it's been studied. There are a lot of researchers who certainly will agree with you, but I offhand don't know of any court cases that have dealt specifically with that. I'm saying under our general concept of opportunity for sound basic education, you could make that argument. It wasn't one of the specific details we went into in CFE. We did go into class size, quality teachers, things like that, computers, up-to-date textbooks. Okay.
Does your case, or is there any move nationally to eliminate the property tax as the basis for school funding?
The question was whether there's been any move in our case or nationally to eliminate the property tax. And the basic answer is no. There have been some moves along those lines. They're not only always 100% successful. In California, you know, I mentioned they were the first case out of the box after the Supreme Court turned down this fiscal equity notion. And they came up with an order that would have called for complete equity in funding. And they said no school district could spend more than $100 more than any other district. That was the maximum discrepancy that would be allowable. That led to a taxpayer revolt, and that taxpayer revolt led to, what do they call it, Proposition 13, I think it is in California, which put a lid on the property taxes. So you might say, okay, you couldn't raise much money for property, through property taxes in California. I think it's a 1% cap and a very low valuation. So it left it to the state to fully fund it. But over the years, the state hasn't come through there. And basically, when we look back at the history of what's happened with these fiscal equity cases, California is not a shining example of a success, because the court there ordered equality, and with this taxpayer revolt and the lid on taxes and the legislature over the years being unwilling to step up to the plate, what you have is a leveling down. It's more equitable. There can't be huge differences among the districts, but the court didn't say anything about what level it has to be at. So people expected it would be a leveling up, but it's been a leveling down. In California, at the time they brought that lawsuit in the late 70s, was 5th in the country in per capita spending. Last time I looked a couple of years ago, they were 47th. Now, Governor Brown's done a bit more. They've raised the funding there a bit, but it's been a disaster because it's leveled everything down. And now it's a mainly Latino system, and you know, all kinds of racial things come in there. The legislature historically has been less willing to pay for it. That's why the approach we took in New York was not to emphasize equity, even though that sounds like a great word. We emphasize what we call adequacy, that we have to raise the level, and we're trying to define the quality level, and all schools below that should be raised to that level. And we did it without playing Robin Hood. We didn't say take the money from the rich district. We said leave them alone. We don't want a bloodbath politically, but raise the level in New York City and other underfunded districts. And we have achieved that to a great extent in New York. Not as much as we'd like, but we have raised the level in New York City and other district significantly. Okay, I think maybe we could take one more. Okay.
Like, the Board of Ed used to have a big warehouse and you got supplies. Then it became the teachers got a budget, $30 or something. But then, like now, when was it under Bloomberg, that the principals got a pile of money and said, go buy the books with it, hire the teachers, run the custodian thing,
Right.
and here are people who know nothing about running an organization of that size, get this bundle of money, and a friend who's a new teacher, well-educated, is suffering in the South Bronx. This principal wants to hound the experienced teachers out because it costs her more money. So she's really hounding people who are very experienced and work there with a lot of experience to get out because of her budget.
Yeah. Well, look, that's a policy decision. You're right. Bloomberg wanted to decentralize a lot of authority to the principals in the schools. I know after he left, Carmen Farina started pulling some of it back. But it's a complicated system. And you know, the courts don't look over the details of everything that mayors and school chancellors are doing. So that's something that, if it's a problem, I think people have to deal with politically or within their local schools. But you know, we all know, and my daughter's been a teacher and tells me every teacher knows the whole game is if you have a good principal in the school or not. And that's one reason teachers move around a lot, I know, to get a school with a good principal. So until we have uniformly high-quality principals in every school, I don't know that you can totally solve that problem.
Michael, one quick question and then we'll stop.
Okay.
How does the money come? Does it come in on a schedule? How does the money?
From?
Yeah, the extra money that you get as a result of it.
Oh, the CFE money?
Yeah.
No, it's part of the state budget. So they're supposed to be increasing the budget every year. They should have done it years ago. And once we reached that higher level, that was going to be $9 billion more than it was in 2007, then it would remain at that level until the next court case said that wasn't enough. But we haven't gotten to that level yet because Cuomo's been holding back, I'll put it that way.
And again, this may be a naive question, but there aren't any restrictions on when the extra money comes from the state to the city.
Oh, I see.
Yeah.
Yes,
Are there restrictions on it?
There were restrictions, but it's taken so long that the restrictions have become meaningless. It was Eliot Spitzer, remember him? He was the governor at the time this foundation aid formula was adopted. And you can say all kinds of things about Spitzer, but for us, he was the best governor ever when it came to funding, because he's the one that got the legislature to adopt this $9 billion increase and commit to it. And that was really ironic, because he had been the Attorney General that was fighting us in the case for 8 years. And you know, his constituency, he was a liberal Democrat. His constituency was basically the same as ours. He was backed by the teachers union, all these other people. And I know the teachers union people went to him and said, Eliot, what are you doing, carrying Pataki's water, and you're fighting this funding case? But he said, you know, it's my obligation, I'm the Attorney General. So I always say, I wish I had been a fly on the wall in his psychiatrist's room to talk about, well, for other reasons, I know. But on this one, what is it called, cognitive dissonance, that for 8 years you're doing what you don't want to do, and he finally got the chance, and it was almost, I think, his opportunity to pay back and make sure the kids really got a good result out of it. But unfortunately, he got involved in all that other business and didn't stay governor. If he had been the governor, we probably would have gotten all the money pretty quickly.
Michael, thank you